Hello, hello. Welcome, everybody. Good morning. I hope you can see and hear us well. So today, and welcome back to Curium Academy. If you haven't been here before, we've been running these webinars for, 2-3 years now, and they're just getting more popular. So please suggest to your colleagues to attend the next one. So today we have chosen an interesting topic, but we want to talk about the duties of directors. And as we were developing the content for that, we've realized that we also need to add responsible managers into the mix. Because over the years, we've been kind of throwing the terms easily, and we've been also throwing the terms obligations, but we've never specified who is actually responsible and accountable for what. What's the difference? What are the penalties? And when especially a firm is getting an AFS license, we have a feeling that people don't always understand what exactly they're signing up to. So whilst we're not going to go through the whole range of AFSL obligations today, but we're going to single out some of the most important ones that are specifically relevant for directors and responsible managers. Today, we have, myself, you already know me, I'm the CEO of Curium, and we have a wonderful co-host, Razan, a managing principal at PC Legal. I'll let Razan briefly introduce herself and PC Legal, please.
Hi, everyone. Thank you for joining us today. I'm so pleased to be part of this event. And thank you, Tatiana, for the kind invitation to join and just share some thoughts and knowledge around directors and officers' duties, and also the role of the responsible manager as well. PC Legal is part of the ProCare group, and I'm very pleased to be able to provide some insights into risk management, which is a real passion of mine, and particularly in the context of the insurance industry as well, which I'm sure many of you are also part of.
And you already know Curium. We are very big on use of technology, but also use of simple English language to take those very, very complex terms, break them down into simpler parts, and put them into practice. Don't just leave them on paper. All right. So our agenda for today, we're going to speak about 3 parts. If you've got any questions in the meantime, please pop them in the chat. And at the end, if we've got time, we will respond. And if we run out of time, both Rosanna and I are happy to take some of them offline. All right. So we're going to start about just understanding the duties of directors and responsible managers. And we're going to have a separate understanding of duties of directors with AFSL and without an AFSL. Then we're going to, of course, speak about penalties and enforcement action, what's been happening in the last years, and if you've heard about it or not. And finally, we're going to go, almost as usual by now, through some best practice examples of what can help you complying with either your director or your responsible manager duties. So some kind of strategies, tips and tricks. All right, let's start with the first one, understanding your responsibilities. Now, before we go into this, and many of you have seen the slide already, I just wanted to remind you that when you operate a business in Australia, and when you especially operate a financial services business in Australia, all these regulators on the left-hand side, ASIC, APRA, ACCC, and so on, they all have something to say in the form of laws, okay? So a lot of your duties come from those regulators, and they come in the form of laws. So on the right-hand side, these are examples of laws. This is by no means the exhaustive list. These are examples of laws that regulate either operating a company in Australia or operating a financial services firm in Australia. So, and as I said before, multiple times, operating outside of these boundaries is an illegal act. Now, let's go into the specific duties, and I'll pass on to Razan here.
Thanks, Tatiana. So today I want to go through the various duties in the context of directors' duties codified by the Corporations Act, and also some very relevant decisions during the course of that discussion. It may take a little while, but I've tried to make this as illustrative as possible so as to keep your interest and also perhaps take you on a trip down memory lane when it comes to the three major decisions that I've set out here. So just in terms of some context with regards to directors' duties, it's often best to start with the concept. So a company in Australia is a separate legal entity, and directors and officers of those companies, and that can include a responsible manager as well, have a significant amount of power and influence. And with great power and influence also comes obligations as well. So different entities and parties that directors and officers will have responsibilities to include the company itself, shareholders of the company, employees in certain contexts, and also customers and the public as well. And you'll see that distinction when we have a look at the differences between responsible managers and also the director's duties. The sources of these laws have evolved over time, and there is a lot of common law and law in equity which sets out these particular responsibilities. The Corporations Act codifies the principles, and there's also other legal obligations, as Tetiana mentioned, in various other pieces of legislation and obligations, as I'm sure you know, to ASIC, APRA, the OAIC, the ATO as well as AUSTRAC. So the main obligations you'll see are listed here in the slide, is to act with care, skill and diligence, to act in good faith in the best interest of the company and for a proper purpose, not to improperly use your information or position as a director or officer of the company. And another significant one, which is the subject of a lot of legal actions, is to prevent trading whilst insolvent. There's also obligations such as disclosure to ASIC. Say, for example, when you get a new director, you have to lodge various forms notifying ASIC within a certain period of time that there's a new director or officer of a company, and other laws as well that we'll touch on. So the first thing I want to look at today is to act with care, skill and diligence. So the test for this particular maxim is to exercise your powers and duties as a director or officer with the same degree of care and diligence of a reasonable person if she were a director or officer in the circumstances of your particular company. Things that you can do to ensure that you abide by this duty are to be familiar and maintain familiarity with the fundamentals of your business, stay informed about appropriate and make appropriate inquiries about an organisation's activities, monitor your organisation's affairs and policies, and to have an informed opinion. If you have a question and something doesn't look right, you actually need to ask the question. That's your responsibility as a director and an officer. And a really good example of this was a case which I'm sure many of you are familiar with, or you would have at least been familiar with the reports in the papers involving James Hardie Industries. So ASIC commenced proceedings against James Hardie and a number of its not just directors but officers as well. James Hardie, as I'm sure you'll know, supplies building materials and has done so for many, many years. And there was quite a bit of litigation in the various dust diseases tribunals around the nation on account of people suffering illness as a result of exposure to asbestos. In 2001, James Hardie established the Medical Research and Compensation Fund and made a public announcement that the MRCF was fully funded and would provide certainty to victims seeking compensation from James Hardie. It was later revealed that the fund was actually underfunded by more than $1 billion. The basis of the proceedings commenced by ASIC was that the directors and officers of James Hardie breached their duty under Section 180, that is to act with care, skill and diligence, by approving the misleading announcement that had been made to the Australian Stock Exchange regarding the funding available to victims. The penalties were very serious. 7 non-executive directors, the CEO, the CFO, the general counsel, and also the company secretary were found to have breached their duties in 2009. They were disqualified from managing companies and ordered to pay penalties themselves. And this decision was upheld by the High Court in 2015. So I guess the major takeaway of that particular case, and in understanding that duty that you have as a director, is don't just rely on the advice that you're given without question. If it requires investigation to satisfy you of the facts and circumstances, you need to make those inquiries. And you also need to be informed about the activities of your company and also the finances of your company as well. The next set of litigation that I wanted to talk to you about is in the context of acting in good faith and in the best interests of the company and for a proper purpose. So directors must exercise their powers and discharge their duties in good faith and in the best interests of the corporation and for a proper purpose as well. I'm going to take you on a little trip back to the late 90s and early 2000s now, when the face of the insurance industry was very different. HIH was a major player in insurance in Australia. There were massive payouts for public liability claims and workers' compensation claims. And it was before there was the IP review into negligence and torts, which brought about the Civil Liability Act in New South Wales, which was later followed by other jurisdictions. So a lot of insurance companies were losing a lot of money, and HIH was no exception. And HIH was very bullish in terms of the investments that it was making as well. The first in this series of cases that I just wanted to look at was ASIC's proceedings against Rodney Adler. The test that was applied in assessing whether Mr. Adler acted in good faith was that of the reasonable person in the position of that director. Mr. Adler had made some clandestine arrangements with some other directors of HIH to borrow $10 million from HIH. One aim of those borrowings was to actually purchase HIH shares to increase the share price. The arrangements had not been disclosed to the board of HIH. Money was channeled through an investment company, and the idea was that once the shares would purchase, the company would be in a better financial position. Unfortunately, that didn't work for HIH, and the company continued to lose money. HIH became insolvent in March 2001, and the collapse of that entity was Australia's biggest ever corporate failure, and Rodney Adler was jailed, as was Ray Williams, who was also jailed for misleading shareholders about the financial position of HIH. A royal commission followed, which I'm sure many of you will be aware of, and the findings of the commission, which lasted for a very long time, were that there was poor corporate governance in regards to the board and senior directors, and they were criticised for having poor decision making and oversight. And that decision and those decisions and oversight were not of the degree expected of somebody in their position. They had inadequate risk management, which again we'll touch on later in the seminar. And they also were very aggressive in their acquisition of other businesses. Another interesting point made by the Royal Commission was that there was inadequate oversight by regulatory bodies, including ASIC and APRA. And this particular event, Royal Commission case study, is really the genesis of the enhanced powers that you now see ASIC and APRA having, and has led to an environment in Australia which is probably one of the most highly regulated environments when it comes to directors' duties and compliance.
Yep.
Another case that I just wanted to point to was looking at not improperly using information or position and managing conflicts of interest, which is closely linked to disclosing directors' interests, the latter being disclosing directors' interests to a board so that then they can hopefully manage any conflict. This particular case involved a person who's probably very familiar to most of you, which is Steve Vizard. And it's the same Steve Vizard of Fast Forward, who was a very well-known comedic actor in Australia, a very accomplished man. He was on TV, he was on the radio, he was Father of the Year, and also a Gold Logie winner in Australia. Also a very intelligent man who had a number of business interests, including being a director of Telstra. He was involved in a series of litigation with his former accountant, who he claimed had stolen money from his family companies. And in 2001, he commenced an action against his accountant, who at the trial alleged that Steve Vizard had engaged in insider trading in the year 2000. What was alleged and later followed up via an ASIC prosecution was that Steve Vizard had been made aware through his position on the board that Telstra had intended to purchase tech shares in a number of tech companies, including Sausage Software, Computershare and KeyCorp. Vizard's family company, via an investment firm, purchased shares prior to the Telstra purchase. Unfortunately for Steve Vizard, he didn't make any money on that transaction either, but that didn't matter. The court still found that he used his position for the purpose of benefiting himself. There was some agreement and a notice of agreed facts entered into between Mr. Vizard and ASIC so that they didn't need to go through the purpose of a hearing, but the matter was put before Justice Finkelstein, who considered this to be a very serious misconduct. And although it had been agreed between ASIC and Mr. Vizard that he be disqualified only for a period of 4 years, Justice Finkelstein increased that to 10 years, and Mr. Vizard had to pay a fine of $390,000. I'll only briefly touch on preventing insolvent trading, because otherwise this is going to go for entirely too long. But a director has the obligation to ensure that it does everything possible to not incur a debt and therefore become insolvent, and certainly not to trade whilst insolvent as well. The myriad of other obligations of directors covered by the competition and consumer law, health and safety law, privacy as well, which is becoming extremely regulated, and probably something for another seminar, Tatiana. Environmental law as well, and taxation law too. So I'll just briefly look at AFSL holders' duties as well. So in the context of having an AFSL, you've got to comply with the ASIC regulatory guides. And those regulatory guides include a requirement to provide services efficiently, honestly, and fairly. And that's also codified in the corporations law at section 912. To maintain adequate financial and human resources, you have to maintain competence to enable you to provide the financial services. In terms of resources, the sorts of things that you need to look at: do you have adequate financials? Do you have adequate technology, which is a big one now? And also, do you have you kept your key staff? Are you ensuring that you train your key staff? Risk management systems are also required, and these are set out in more detail under RG 104. The formulation of RG 104 is very much in line with Australian and international standards for risk management, such as ISO 31000. And it's a tool to enable people with AFSL licenses to ensure that their business is going to have longevity, that they're going to be able to provide the services without disruption to their clients. Dispute resolution as well, I'm sure you're all very familiar with as well, that there has to be an adequate complaint system in place. There are lots of timelines that need to be complied with, and also there needs to be membership to the external dispute resolution scheme, which is AFCA. Disclosure requirements are also important as well. So your financial services guides, product disclosure statement, and statement of advice as well. And these are all things as well that if you do get audited, all of these things will be checked. If you don't have adequate systems, you may be required to undertake some kind of remediation action, but also you could have your license cancelled as well. It's also important that you have adequate professional insurance cover in place. And another one that's not on this list is breach notifications also, and the RG 78 deals with those. So I just want, in the context of this, I just wanted to, I guess, give you some insights into what ASIC uses to monitor licensees. So it has a number of different methodologies that you should be aware of. It will monitor your websites for any misleading or deceptive information. It will have regard to whatever breach notifications you provide to it. And the question that's being asked is, what have you done to ensure that this will not happen again? What process have you put in place to ensure this will not happen again? What kind of risk management system do you have to minimise the reoccurrence of the breach? They can also conduct shadow shopping operations, and they'll recruit consumers to get financial advice from you to ascertain the level of competency. And they'll also act in response to client complaints as well that they might receive. They could randomly send you a questionnaire and ask you to fill that in with a view to ascertaining what is the strength of your compliance system. And also just remember, AFCA is required to report to ASIC every quarter about the complaints that are made against you. So again, that might be the catalyst. If you do get audited, one of the first things that they're going to look at is they're going to say, okay, well, show me your risk register, show me your complaints register. If there's nothing in those, that is a red flag for them. Any business is going to have issues. If you're not properly recording things, that is an indicator to them that you have not got an appropriate compliance piece in place. Okay, so we might go to the next slide, Tetiana, if that's all right. Okay, so responsible managers, what do you need to know? Any of you with an AFSL license are going to have been through that process of applying for it, and you have to set out what the responsible manager's qualifications are, and ensure that you have these particular standards and competencies in place. There have been some incidents recently where ASIC have investigated whether a responsible manager has the necessary skills, knowledge, and experience to perform the role. And the other arm of that is to ascertain whether there is compliance with the regulatory obligations too. One way to look at this in terms of directors' duties versus the role of the responsible manager, the primary obligation of directors is to the company and to ensure that the company's best interests are served, the company's stakeholders' interests are served. When it comes to responsible managers, the focus could be seen as client focused, and also to ensure that you have the ability to provide and perform the financial services. It can be the case if you have a small to medium enterprise, such as, say, for example, a brokerage firm, that you want someone in that responsible manager role that's going to be around for a long time, because to go through the process of having someone be recognized as a responsible manager does take some time and effort. And quite often, if you have a small to SME business, it may be someone that's also an officer of the business as well. But it's important to recognize that there are two hats that that person would then be wearing. So just in terms of what's on the slide here, we've got the core competency requirement, and I'll give you an illustration of that in a second. The fit and proper person standard, ongoing monitoring and compliance, and that can be very onerous if you haven't got a great system. It's not something that you can delegate the function, you cannot delegate the responsibility. So the better systems you have in place, the easier your job is going to be. And notifications as well. So just the example that I wanted to give you in terms of recent action that's been initiated against responsible managers themselves by ASIC is a fellow by the name of Albert Waters, and he failed to monitor and oversee his business and failed to ensure compliance with financial services laws. He ceased actually to be present in the company for quite some time. So a bit of a figurehead type character, semi-retired from the business, but he was still the responsible manager. And so the biggest complaint that ASIC had in that particular circumstances is that the business, the company, the licensees ought to have arranged a new responsible manager, and he himself ought to have put those steps in place. There's another case of the responsible manager for Cirrus Financial Markets, a fellow by the name of Mark Briggins. He was banned for 8 years after a finding that he was inadequately trained and incompetent. It was further found that he was not a fit and proper person and did no more than attend monthly compliance meetings when it came to fulfilling his role as a responsible manager. So it's certainly something that you need to take very seriously. He appealed this case to an administrative appeals forum, and he failed. So it's probably something that's going to be enforced more and more by ASIC moving forward. Okay, so just here again, a bit of a recap in terms of the differences between directors, responsible managers, and senior management duties. If you see on the left-hand side there, we're sort of looking at particular roles. So overall responsibility, legal and fiduciary duties, day-to-day responsibilities, regulatory accountability, and compliance oversight. And this is a really good illustration of the fact that directors' duties are more focused in terms of responsibilities to the company. It's about oversight. It is about ensuring certain compliance with the company's operations, and more of a, I guess, a helicopter view. That doesn't mean to say that you shouldn't be informed about as much as possible. If you have questions, having advice is not enough. You need to make the appropriate inquiries. Responsible managers, on the other hand, is very much focused on AFSL obligations, and you're going to have particular conditions put on your licenses as well. You need to be very familiar with those and ensure that compliance with those also. The second point on the right-hand side says, the same fiduciary duty is not held as directors, and that is absolutely true because that duty is a fiduciary duty to the company. However, as we've said before, a responsible manager may also be an officer of the company as well, depending on their particular role. And also, ASIC can take action against responsible managers. It's not just it's not just directors. So I think we might move on because I'm sort of tracking a bit behind time here. So we've got some examples of some penalties. These are typical for AFSL holders. The main penalties will be a license cancellation. There could be a civil penalty, so that's a payment of money. And there also could be a banning order, which was the case in the Cirrus Financial Markets case that the responsible manager was banned for some time. There are some other cases here, and it can be as simple as you failed to lodge your audited financial accounts. All of these things are not just breaches themselves, but also red flags for other investigations that can be undertaken in relation to your organisation.
Roseanne, if I may, we have a question here. Just wanted to
Sure.
put it because I think it's thematic. How long can a responsible manager be unavailable, for example, on jury duty before you need to notify ASIC?
Oh, gee, that's a really interesting question. I think it would depend on if the absence materially impacts on the operation of the business and the business's ability to be able to comply with its its obligations. And I think if that you're ever in doubt, that you should notify of an instance. That transparency is very important. I mean, not that many jury trials are going to last for a material amount of time. Does the person that asked the question actually have this circumstance, and do they have a time frame?
We can take it offline.
Okay, all right, we'll take
I'd
that
say
offline. I'm
from
interested to speak to you.
yeah, so from kind of my perspective is it also matters what's going on in your business. Let's assume you're head of claims and you're signing a very, very important outsourcing agreement. That's a red flag if you're not there, for signing it. That's kind of, it very much depends on what else is going on in your business and how much not involved are you. Are you aware of it? Are you making the decision? Are you letting someone else make that decision? Because all of that matters.
Yeah, absolutely. And, there's modern technology these days. I mean, you may be on a jury trial, but you may be able to, depending on your commitment to your business, be able to have some oversight in the wee hours of the morning to ensure that everything's going okay. Should we move on, Tatiana?
Yeah. All right. So we've heard about the theory and the laws and some of the enforcement action. Now, I hope you're not scared too much, but there are good ways of making sure that you comply with both your director duties and your duties as responsible manager. We want to share a few kind of best practice and potentially some worst practice. We've tried to group them together to make it easy for you to understand and follow. So one we've grouped under people, knowledge, and culture. Second one we've grouped under effective oversight, what Roseanne was talking about. It's important to ensure that you have a good visibility into your business, no matter if you're acting as a, working for a day-to-day or just, dialing in or participating in board sessions. And finally, process and technology. I think she touched upon this a few times. So let's go into people and culture. So first and foremost, you need to know what the laws are. There's no way around it. In your position, no matter as a director or as a responsible manager, you need to know what applies to you. So we tried to show you the examples and the most important things, but Roseanne did allude there's a bit more. The best way, in my view, practical way, is to have those laws and standards spelled out in your obligations register. I find it the most easy and comprehensive way to actually understand where does the law end and what's outside and what do I need to know. Then obviously you are subscribers to various codes, so it's important to know what they are and what they say. And for a lot of businesses, especially the ones that deal with large insurers, you will have some very, very large, significant contracts like binder agreements, agency agreements, SLAs, and so on. All those form the core of your regulatory obligations. As I said, the best place for them is an obligations register. You actually have to know what they are. Whilst you can not expect from everyone else in your firm to have an idea, they might have an idea about specific things that relate to their jobs, but you are the one who needs to know. Next one is invest in knowledge and training, both of yourself, but also people who you rely on. Okay, and they can be responsible managers or not, or they can be just very important people who do the job for you and then present, results and outcomes. And the most effective training, and we've been talking about it for many years now, is examples. Give as many practical examples. Let's say a breach looks like that. And for your job, it would be, for example, if you've got only general insurance, so general advice license, you cannot suggest people what kind of policy they should buy if you're not entitled to do that. So as many practical examples as possible. And finally, you are only as good as your worst employee. So we can, invest in systems and have the best documents and the best technology and whatever. But in the end, if you're to fail, you will fail because someone made a mistake somewhere, not necessarily you. But what you need to know about those mistakes. And the sooner you know about them, or I'm not saying it should be caused by your employee, but it might be overseen by your employee and not, your employee doesn't let you know. So the worst thing that can happen is that something spirals out of control, snowballs, and then you have to deal with consequences. It personally happened to me. It was a 2-week delay that resulted in a 3-month, ASIC and other unpleasantries. If I had known earlier, I could probably have solved that straight away. So what we kind of work on with our clients and are standing strongly behind is the culture of see something, say something for everybody, no matter how senior or junior people are in your business. The next bit is about oversight. So it's very easy to say, yes, I'm overseeing and I know what's going on. We find, however, in practice, there are a few kind of big mistakes that people make and don't realize that they make them. So one of the things we always emphasize is less is more. When you say I'm going to oversee, let's say I've got an AR network or something, and when I say I've got 150 controls to oversee them, I'm probably lying to myself, and most importantly, I'm lying to a regulator. In our view, the fewer effective controls you have and the more thought through they are, the better you are actually overseeing something. I'll give you an example. Let's say you're doing file audits. There's a different quality of file audits, right? There's just a scan through file audit, or there's a file audit that takes into account your regulatory and your AFSL obligations and has specific sections in those to address them. Those are good file audits, and they should be covering maybe between 40 to 60% of your regulatory obligations and potentially a big portion of your risks. So for us, what we know works is good actionable controls, but not too many of them. And it's also easier for you to oversee if you only have to attend, let's say, 3 meetings a month where you get a good oversight of everything that's going on, rather than go to 10 a week and try to piecemeal all the things that were said and they're not necessarily connected to each other. It's going to be really hard to oversee. Then commit to what you realistically can execute. And I know it sounds very mundane, but again, in reality, we often, when we come and, to start working with somebody, they share their documents with us and we get these like fat binders and documents where they speak about, oh, this is my risk and compliance framework, and it's so extensive, and you read it and they've overpromised significantly what they're going to do, and when you compare it to the practice and reality what they are doing, it's not there. Now, not is it only bad for you to run this, it's probably the worst thing you can do to yourself when dealing with regulators. Because whilst regulators' job is to make sure that you are adhering to the law, they will look first and foremost at what you said you're going to do and how you would go will be adhering to that law. Very, very simple, bad example I'll give you. ASIC provides something like, I forgot, 17 or 19 mandatory fields that you need to collect for them to manage a complaint. I've seen a firm who decided that they're going to be collecting 56 per complaint. Well, guess what? They're not. And they're kind of breaching their own process that they said they're going to do, just because, in my opinion, that process was not realistic for them to execute. And finally, transparency through data. ASIC, APRA, and every other regulator around the world is investing in data capabilities. They don't have potentially physical capabilities to come and do manual audits on you, but they very well have capabilities to go and mass scan your websites and your documents and your data. And not is it only coming from the regulator, it should also come from you, because when you want to make adequate and transparent decisions, you actually want to make them based on facts, not based on he said, she said. So data is the way forward. And finally, processes and documents. So again, it's very easy to say have the right people and the right technologies. It's, the question of the century. But kind of a few suggestions here. If you run, no matter how big or small business you run, you have to make sure that you empower your key people to make decisions, but also to build a trusting relationship with them. What happens too much, for example, when a new law is coming out, those key people get dumped with a whole bunch of extra things that they need to do and squeeze into their working day in addition to what they're already doing. That's usually a bad practice, and this is where a good technology comes in place. If you want them to do more, you have to be very honest about the number of hours in the day and what they're going to do it and how they're going to do it. And if you're not going to give them the right tools, your overall productivity is going to drop and something will fall through the cracks, which you don't need. Document decision-making process easy. Again, I mean, it's almost obvious. If you make very, very large decisions, just don't forget to put proper documentation in place, especially on due diligence for key suppliers, any big underwriting decisions or guidelines, claims, and so on and so forth. And I would say for very large decision, always have a 4-eye principle. Let someone else look at it, sign it off, and get a good 4 eyes minimum, obviously, but good process of validating each other and having your responsible managers look at the same thing. And of course, never forget about authorized reps. They are your responsibility if you hold an AFS license. Have a framework for effective oversight. My kind of suggestion for it, don't tell me, show me. So if they have to do something for you and for you to monitor them, have access to that data rather than, use attestations for them to tell me that nothing happened or something like that. But I mean, it's a choice, obviously. Best practice is to actually give them as many tools as possible. So risk and compliance methodology, tools, manuals, frameworks, and so on works best, rather than sit there and wait for them, to reinvent the wheel. And finally, they also have regulatory obligations, not as onerous as yours, but it's very important that they understand it. And again, you can rely on them just doing that, or you can go train them. I think we're out of time, and I will leave potentially 2 minutes for any questions that you've got. As I said, if you've got the questions, send them through. You'll get a certificate for participation for this one. I hope you like it. Please give us feedback and things that you want to know next. Just a quick reminder, next week we'll actually be running through regulatory obligations for a firm, where we go into a little more detail or a little more breadth of what the laws are and what the codes are and what they say and how to manage them. All right. Thank you so much.
Thanks, everyone.
Have a great day.